People versus Kevin Cleveland.
Good morning. May it please the court, Brad Keem, if I could, 3 minutes for rebuttal.
Yes.
Thank you. Reasonable suspicion is not static. Here, law enforcement observed a woman throw a bottle at a car. Mr. Cleveland then exit his car, stop it in the middle of the road, approach her with a clenched fist in an aggressive manner. But then,
Well, at that point, do they have reasonable suspicion to believe a crime is about to be committed?
we would argue in our brief that they did not, but
But why not?
Why not?
Why not?
why not is because
I mean, look, it's a dangerous enterprise. You've had a bottle thrown at you. You're going to get out and now confront the individual. How is that not that one can infer that you're not merely just going to stand there. You're actually going to take some action.
So I think if we said there was reasonable suspicion there, then throughout New York City, every time two people are arguing on the street, then police officers could come approach them.
But shouldn't they at
Is that a
times
bad rule?
to approach? If the officer kept driving on and she was assaulted, shot, stabbed, then there would be outrage.
Your Honor, I don't think we get that far in this case because we don't have any.
Because the police officer stopped.
Well, we don't have any evidence in this record how close he got to her.
There
or-
was
It
more
was
than that, wasn't there?
interrupted.
The car, he left the car, I think, just in the middle of the road. That's pretty unusual. And not just two individuals facing off against each other.
It is unusual, and
And when you get out of a car and you leave it running with the door open, that's not a person stopping and being calm. I just want to have a chat. That is an indication that perhaps things may escalate, causing a police officer to take appropriate action. Why is it wrong for the officer to act in that manner?
so from the questions the court is giving me, and because none of the appellate division justices agreed with me either, I would like to pivot to when we have these secondary actions, okay? Reasonable suspicion, like I said, is not static. It evaporated.
I'm not sure, yes, I'm not sure you can pivot that quickly. Because if we assume that the officer had reasonable cause to detain because the officer believed that your client was about to commit a crime, right, an assault, and it's the officer's intervention that stopped that from happening, at that point, does the officer lose the ability to detain?
I think that when Mr. Cleveland stopped and left, he ran away, that at that point, reasonable suspicion or reasonable cause evaporated.
So I'm a police officer, I see somebody about to commit a crime, I say, hey, wait a minute, stop. The person stops, and then we let them go.
We also have a woman that committed a crime by throwing the bottle at the car.
Police don't arrest everybody, maybe, that they should.
Certainly, but the more prudent action would have been to let him go because they have his car, potentially. They have the woman.
Well, they don't even know it's his car.
It's possible. I mean, the car did disappear by the time.
Would you have a different argument if they detained her and pursued him?
Potentially,
I know you
because
spent a great deal of time in the brief, and I appreciate it, that there is a person who obviously did commit an offense, who seemed to still be there at the time, but had left by the time they got back with the defendant.
potentially, Your Honor, especially if she was able to provide more insight and information as to what was actually transpiring here, which I think there are a lot of unanswered questions.
So if you assume that there was level 3 up until the point that he starts running, are you suggesting that a suspect could flee a reasonable level 3 stop by running away from the police? Is that a rule that we should adopt?
Certainly not in all cases, but I think in this case, when he stopped, turned around, and ran away, that there was no crime and no crime about to be committed. And
How do you know?
Why can't we say that running, then, if you're suggesting it wasn't enough to get to level 3 before, that the running away certainly tips it to a level 3 now, once they decide to take off.
I don't think that it tipped to reasonable suspicion.
On foot without his car.
Right.
Pretty unusual.
It is unusual, Your Honor, but I think the more prudent choice, and that's what we want to
So you're
encourage.
saying that even if they had reasonable suspicion before, because the defendant stops engaging in that which gave them that reasonable suspicion, or appears to have, let's try appears to have, the officer's supposed to accept that and just let him go about his way?
I believe that's the more prudent choice. When the
And should they
officer,
stay at the scene then, though? I mean, how long do they have to stay?
they could, if the car was truly abandoned, then they could have conducted an investigation with the car and with the woman
But-
who was
and
left
then-
behind, and then potentially have gotten him in a much safer manner.
Let me ask you this. Suppose I'm driving down the street in my car, and there happen to be some officers in an unmarked car behind me. I don't know that. I get out of my car, leave it running in the middle of the street, and either walk off or run off. Let's just say walk off. I just leave. Can the officers follow me?
I would say no. I would say that they would have public safety would demand that they investigate the car as opposed to you. It is your choice to abandon a car. You are not committing.
In the
a
middle of
crime.
the street?
The car is the issue, I think.
Do
that-
they have some discretion to determine what might be the best act to pursue, given the public safety?
Absolutely. And I think in this case, the public safety part of it would be to have let him run and then continue their investigation in a safe manner.
But counsel, doesn't discretion imply that they could choose to do one or the other as long as there were reasons for making that choice?
Certainly, within the context of reasonable suspicion, which we assert wasn't present at the
What if
time.
somebody drives a semi in front of a childcare center in Oklahoma City and walks off? The police can't follow him? You got to stay with a truck?
Your Honor, certainly that is a difficult
Yeah.
hypothetical. But we would maintain that this was not a truck in front of the Oklahoma City Safety Building, and that the case
Where do you
then
draw the
was
line?
different.
To the Chief Judge's question, where would they draw the
Certainly,
line?
that would be a different
What if someone
scenario.
looks like they're breaking in a building? It's night, they look like they're breaking into a residence.
Right.
Police come up, guy runs. Can they follow him or not?
I would say the line is this case. The line is.
Why? Why is that different than the person breaking into a building?
Because you have a crime, if they look like they're breaking into a building, then the reasonable suspicion calculus is much different.
If they run away, they're not breaking in the building anymore. Isn't that the same?
I guess I misunderstood your hypothetical then, because,
So they're by a window, it looks like they could be doing something to get into this building. It's night, there's nobody in the building. Police see that, they pull up.
again, if
Get out,
if they
the
look
person
like
runs.
they're looking inside of a window in a suspicious manner, I think that's different than simply turning and running.
But no, here, the threat was assault, right? They had reasonable suspicion that this person was going to assault someone else. And it seems to me, in the dissent at least, that no longer applies because the person isn't about to assault anyone anymore. So on that logic, why wouldn't that apply to somebody who moves away from the window? They're no longer about to break into a building.
Oh, okay, so you're saying he looks in the window and then runs away upon saying stop.
And say you have reasonable suspicion to believe they may be about to commit a burglary.
Right, and I suppose that's how close we want to get to predictive criminality. And I think that would
Okay, so
fall
what does that
into,
mean here? Is this predictive criminality or not? I mean, why would that burglary case be different? Reasonable suspicion committed burglary, why is that different than this one?
I think because the anger, which was the focus of the assault, had dissipated by him running and moving
My
away.
intent to steal something maybe has dissipated now by my running away too.
Maybe the anger dissipated because the police showed up.
It's certainly possible. I would note that the police did not, they made themselves known. They didn't say,
So is part of what you're arguing that it's at best, from your viewpoint, an attempt, and the person hasn't taken enough conduct to cross the line of an attempt, let's say in this case an assault? Is that? part of
Your
what
Honor,
you're
I
trying
think
to
that
argue?
that's very close
Which may be
to,
different from someone actually perhaps at a door with a screwdriver or something like that.
correct. And I think it would fall on the facts.
But again, isn't that then a mixed question of law and fact?
I think the mixed question of law, in fact, is incredibly interesting here because the trial court used the wrong language. It said probable cause. So I don't think that we can rely on the mixed question of law and fact based on the trial court's decision here. Because that's certainly not what we have here, probable cause.
We also have more in this case, because it's not him just taking off and running, it's him taking off and running and making motions to his waistband, which might indicate a weapon, and if the police thought that he had a weapon, that's a continuous crime, that possession of that weapon. So even if the danger dissipated toward the person who threw the bottle, if he had a weapon, that's a danger to the public at large.
The motion to the waistband is not helpful for reasonable suspicion here because the officers admitted they could only see him from the back and his hands were
They saw him
moving.
going, yeah, from the back, you're right, but motions to his waistband. So I don't think we can just forget it because that's what they testified to. And to your point that everything is static, I mean, we're looking at the totality, the circumstances of an encounter. And I don't think we can ignore that in this encounter.
I understand not ignoring it, and maybe I misspoke. I just don't think that it is a very strong factor in the reasonable suspicion determination.
Doesn't it fall under the mixed question issue? I mean, I think the officer's testimony was that the motions toward the waistband raised in their mind the notion that defendant might have a weapon on him, which was in turn credited by the courts below. Can we now revisit whether that should be credited or not?
Again, I would say that yes, it can because the trial court used the wrong language, probable cause. So
I understand they used the
Okay.
wrong standard, I agree with you, but this is just a factual issue that was resolved below. Whether it amounts to probable cause or amounts to reasonable suspicion is a separate legal question.
correct, and I think because there's not probable cause, this court should then decide.
Well, the appellate division used the right standard, right?
Correct. They did.
So why doesn't that take care of it?
I think that this court should still review from the trial court's perspective. I think that should be.
Why?
I think that would be the bet for this court to
What is
have a
it-
final
what is
say
it-
on the issue would be helpful for the
But it benefits the defendant, right?
It-
Higher standard.
It could, yes. It could depending, yes, Your Honor, you're right.
Thank you.
Good morning. Marty McCarthy for the People. This question, this case really does present the classic mixed question of law and fact. The questions that you're asking.
What about the argument, he left? It's over.
You mean the dissipation?
Yes.
You've never held that before. You've never held that you can dissipate a level 3 encounter in that fashion.
So your argument, there clearly was a level 3,
Yes.
and because there was a level 3, the officer had what authority at that point?
As the appellate division pointed out, they had stop and frisk, and they have the ability to pursue. This was not a case where they pursued him, they caught him, they searched him and found contraband. This was an abandonment case. So in the course of the pursuit, he abandoned the drugs. So we don't reach that subsequent, they stop him, and did they exceed the scope of a permissible search in that scenario?
So why is the evidence before the officer sufficient to get you to level 3?
You mean going back to the
Yeah,
initial
going
encounter?
back to the beginning. That seems to me the harder question.
I don't know if I agree with that, but when you consider when you look at the totality of the circumstances of what happened here, the police were just on routine patrol. They were paying no particular attention to the vehicle in front
We
of them.
don't know that actually, right?
They just said that they were driving. So,
Right. They were driving and they were behind this car.
yeah, but they didn't testify
say
that
they
they were
weren't.
behind this car for any reason.
Right, and they didn't say that they weren't.
Yes.
We just don't know.
In that sense, we don't know. But the point is, what they
They see a woman throw a bottle and hit the car.
Correct.
They see a man get out, and leave the car running, I guess, and he is angry and he has clenched fists and he starts approaching the woman.
Correct, and all that happens.
Is that enough to conclude that a crime was about to be committed?
When you factor in it wasn't just that, as you pointed out, it wasn't just that he got out of the car. He pulled the car over to the side of the road. He left the car in the middle of the road.
Yep.
Right?
And how does that increase the likelihood a crime was going to be committed?
Because you're looking at the precipitous nature in which he acted.
Well, the precipitous thing that happened was a bottle hit his car.
Correct. But, and if you want to say that that was an assumption of risk, that she assumed the risk that she was going to get
not at all.
approached.
I'm going back to why is that enough to conclude that a crime was about to be committed?
Because that was an aggressive act on, let's credit it for what it was. That was an aggressive act on her part, right? She engaged in an aggressive act, maybe even a crime. I don't know if it may have been an attempt at criminal mischief.
So what about the argument that it is she who the focus should have been on and not him?
Well, you had the fact that they observed what could have been a crime that she committed, and then as a result of that, it appears he's angry, right? So he is angry.
Victims of crime are usually angry.
Absolutely,
moment.
but angry in the sense of somebody could just be mad that
Well,
somebody.
What if he stopped the car suddenly, opened the door, left the car running, stood by the door, turned and yelled at her?
Can
Would
I,
that be enough? Could the cops at that point
can I,
approach him and try to detain him?
can I just,
Didn't move, just
no, no, I just
exactly
want to,
what
I
I've
just want to
described.
know, stop in the middle or stop on the side?
No, I said stop exactly where he stopped. I haven't
Okay.
changed anything other than he stayed by the door.
If he
Did
stayed
not
by,
get out around and start walking towards her.
if he stayed by the, if he stayed by
And
the,
yelled.
if he stayed by the door and he yelled,
Yes.
that might be a different story. And the reason why that might be a different story is all he's done at that point is commit a traffic infraction. He stopped his car in the middle of the road and he got out.
What if he had parked the car and then got out and the actions were the same? Clenched his fist and walked towards her. But parked the car, shut the door.
I believe that might be a closer case in terms of reasonable suspicion. I still think
So
that.
is
what does the-
is it what turns this from the prosecutor's perspective, the fact that he exits the car and makes an approach, obviously as the officer describes it, this aggressive, angry manner, but it's this approach that makes this difference. When he's
Yes.
just by the door, well, maybe he's not really going to attack her. He's angry, he's screaming at her, anyone might.
That would be, yeah, and that's part of the issue, right? Like, would you say it would be reasonable to assume that the defendant was about to commit a crime in that scenario if he had just stayed by his car?
So would
It's his actions that's revealed.
Would his behavior have been enough to charge him with attempted assault?
That, we don't, that's not required
No,
because it's
but I'm
reasonable,
asking-
it's reasonable suspicion,
May not
but
be required, I'm just asking.
the question becomes whether, in terms of charging an attempt, whether you come dangerously near to committing a crime. Here, it appears that the police intervened before he raised his fist, if you will, right? And that may have been
Well, he's
enough to
got
be.
clenched fists, I guess we don't know if they're raised or not.
He's got clenched fists. We don't know if they're raised or not, yes.
How about
And
all the activity after? So the running away and the reaching for the waistband, is that extraneous?
Oh,
Because your
God, no.
position is that you get to reasonable cause to believe a crime is about to be committed before all of that takes place?
Correct, and even if you didn't, you certainly get there after, right? Because he left, he continued to, you can't flee a traffic stop either, that's the other thing. If you are committing a traffic offense, you can't flee a traffic offense.
So then the appellate division made an erroneous determination as a matter of law on that? Because they agreed with the defendant that merely observing the waistband, that was not going to be good enough.
No, I don't know if they,
Well, I'm looking right at it. Maybe I'm misreading it, but
I don't know if I agree with the way you're characterizing what they did, because what they were focusing on was.
we agree with defendant that his arm movements directed at his waistband and his flight would not, without more, justify police pursuit.
Correct, without more.
Without
And this is, and then they continue to go on to say,
So what is the more?
the more is
What
everything
came
that,
before or what came after?
both.
Well, you're already in pursuit, so how is the after going to help you?
Because once he runs, again, he's running away from a scenario where he's left his car in the middle of the road, right? So what possible conclusion?
So it's the car in the middle of the road, not what appears to be some aggressive, perhaps an attempt at some aggressive act towards a woman, or at least approaching her.
It's all of it. It's when you add, because again, you're focusing on the totality.
So getting back to my hypothetical, been at the door, just yelled. Cops come and say, hey, stop, or whatever they want to say there. And he runs. Could they follow him then?
If he was in the middle of the road, he'd be fleeing a traffic infraction, and I believe they could pursue him in that scenario.
So Ed, let's take Judge Halligan's hypothetical. He first parks the car and then opens the door and starts yelling, but doesn't approach. And then even walks away, forgets the run.
Yeah.
Walks away from the officers, not towards the woman who's thrown the bottle.
If you have no other facts, I don't think they could.
If they what, I'm sorry?
If you had no other facts, I don't think they could. And the reason,
Does it matter at all that the route basis for the police officer changes? In other words, initially, in the initial approach, they think an assault is about to be committed, but then it sort of changes, because once flight happens and they're reaching to the waistband, then they might be concerned about a weapon or drugs. Does that matter?
it only adds, it doesn't subtract. And it doesn't sort of take the place of, because the encounter is the encounter from its inception to its conclusion.
Do we rely on an officer's subjective belief?
Well, you mean in terms of whether he believed that a crime was about to be committed?
Yes.
I think you have to look at the objective facts as well, and the objective facts here would support that conclusion. So if he had just parked his car on the side of the road, maybe those objective facts are very different. But what is an officer supposed to do in that scenario?
Counsel, it seems here you're arguing that the fact that he left the car in the middle of the road, traffic infraction, is sufficient to stop him here when he starts to flee. Is that your argument here?
It would be an independent basis, yes, but there's more to it.
Did you argue that below?
What's that?
Did you argue that in the trial court?
I'm not sure, they did.
As an independent basis?
The court found it as a fact.
And do you get that, are you saying that gets you a level 3?
In terms,
Under
if
DeBoer,
we're just
under
talking,
DeBoer.
if we're just talking about the fact he leaves his car in the middle of
Yes,
the road.
yes, yes.
And doesn't do anything else. and he
Correct,
just- okay.
correct.
I believe under this court's case law, you can't flee a traffic infraction. So if you were to get out, if you were to commit a traffic infraction and then get out and run away.
Because the fleeing is then not an infraction? Because level 3 is about misdemeanors and felonies, not about
Correct.
infractions.
Yes.
Is that the law, that you can't flee a traffic infraction, or you can't flee a stop for a traffic infraction? And are you making an argument that the police officer was stopping him?
No.
To give him a citation for leaving his car in the middle of the road?
No, but we're talking about the totality of the circumstances.
Okay, so, I mean, because my understanding of the record, and, you know, we can all have different views of it, was that what justified the stop was the police officer's apprehension, credited by the court, I think, that he was about to commit the crime of assault.
Correct.
So,
And part of that conclusion was the precipitous nature in which he stopped, leaving his car in the middle of the road, leaving it unattended to approach this woman in an aggressive manner and
right,
yelling
so
at her.
I get that. There are two aspects to stopping the car. One is, it's illegal to stop a car in the middle of the road. You could get a ticket for that. But the other one is, it was very precipitous and
Yes.
sort of angry, like, you know, you picture something like the brakes screeching and he just opens the door and runs out of the car.
Yeah.
But this is more about the latter and not the former, am I, in your view, or am I misunderstanding your argument?
I believe what I'm trying to say is it's all of it, because again, it's a totality analysis. So you have to, when you're talking about how we're able to read the officer's mind to make that conclusion, this is an element of it. It wasn't just a controlled stop to the side of the road. And it wasn't just him standing at the side of the car. It was the nature in which he exited the car. It was the nature in which he did that, despite the fact that there was a car behind him. He leaves the car, he runs to the side of I keep saying run, I don't know if it's run. He approaches aggressively, quickly, the woman on the side of the road who threw the bottle. I don't know what the officers are supposed to do in that scenario. They certainly had justification to believe that he was about to commit a crime. That's what the court, that's what the trial court found, the appellate division affirmed on that. And I would look at that as being the mixed question of law and fact. There are no other questions?
Your Honors, just briefly, there was discussion about the approach and a hypothetical about staying by the door. But this record doesn't reflect how close Mr. Cleveland ever got to this woman. So I think that the idea that he is 2-3 feet away from her, about to punch her, whatever, is just not on this record. And I think that does support our argument of a lack of reasonable suspicion, unless there are.
Well, that might be of some interest if all he did was get up out of the car, walk, there'd been no bottle thrown, get up out of the car and he's walking towards someone on the street. Yes, maybe that appears so benign and innocent that it's hard to say that would give an officer reasonable suspicion or even pause about what might be a very dangerous situation. But it is his reaction. Again, I'm not saying it's not a human reaction, and please do not misunderstand me. But nevertheless, it seems to, as the officer described it, a very aggressive reaction that perhaps put other people in danger, not just the person he might have been going towards, right? He's in the middle of the road. Maybe other people are involved in this. Who knows what's going on?
Potentially, but again, it could be 15 feet away, and that's I
And the
guess.
officer should lay back and wait till he's about 3 feet away?
I think that there's a moment where he has to use his discretion, and that 15 feet may be too far to know what exactly is going to happen in this situation.
Well, you've stopped the car in the middle of the road, left it running, left the door open, you're yelling, you look angry, you've got your fists clenched. You're not just, again, as I said before, it's a dangerous enterprise. You're
Certainly.
not just, going to stand there and do nothing, right?
I understand Your Honor's point.
At least it's reasonable for someone to assume that you might take some other action, if you've gone that far. 'Cause he's put himself in danger, has he not? She already threw one bottle, she could throw another.
It's possible, and I understand Your Honor's point, but we maintain our contentions in our brief. Thank you.
Thank you.